Hello everyone, today I'm going to cover a new section, section 148A of CPC, Code of Civil Procedure. It talks about caveat. What is caveat? Who can file caveat? Who has the power to file caveat, and when can this right be exercised by that particular person? All these questions will be answered in this provision only. So let's get started with it. I'm reading subsection 1 of section 148A, right to lodge a caveat. Where an application is expected to be made or has been made in a suit or proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lodge a caveat in respect thereof. So basically, whenever an application is filed or is expected to be filed in any suit or in any proceeding which has been instituted or which is expected to be instituted, in all these cases, the caveator is the person who has the right to file the caveat. So the caveator will have the right to file caveat in all these cases. Basically, it is a defense whenever a party can anticipate that the opponent or the other party is going to file an application, or it is going to file an appeal, which will make obstacle in the path of getting justice. In all these situations, the caveator can file a caveat. So let's break down this first line. Where an application is expected to be made or has been made, what does this mean? When an application is expected to be made, let's assume that a suit has been filed in a court. Civil suit number dash is being pending before XYZ court, district court. Okay, and the other party has not been summoned in that particular case. It is at an initial stage, and the other party is still is yet to be served, but the order has not been passed. But the party who has filed the suit, the plaintiff side, is going to file a condemnation of delay to file any XYZ application, but they are barred to file that application because there is a delay of around 3 days or 4 days. So in that particular situation, the defendant has a defense to stop them from filing that particular application. So in that case, when the defendant has not been made party, basically they are party to the suit, but they has not been summoned by the court, so they cannot directly appear and say that they are barred from this law, they cannot file this application because they are it is time barred or something like that. In that particular situation, they cannot directly approach the court with any of the defense, but they can file a caveat that the other party is expected to file this particular application, and the court they will make an official request before the court that without hearing them, the court will not pass any will not pass any order in that particular application. It will not grant any relief, and it cannot okay, fine, yeah, so it cannot grant any relief with respect to that application. So this is the first thing in a suit, that an application is made, has been made, or is expected to be made in a suit. In the situation of suit, this is the only situation that can be arise when the other party has not been summoned, except there is an exception here, that if there is a third party which can be get affected by filing of any application in the court, like it's a case of an immovable property, and if the court orders anything with regard to that particular regard to that particular property, the neighbor the neighbor X, name that particular neighbor X, X will get affected by the order. So in that situation, he can file a caveat in that case. So this was what this first line meant. Now let's move on to the other part. Or preceding instituted. Okay, so so what exactly does this preceding term means? So preceding means any civil proceeding. Okay, so there's a difference between suit and civil proceeding. Suit is also a civil proceeding, but in this particular section, both these terms have been differentiated to create a clear concept. Okay, so in a suit there can be some other situations, and in a proceedings also there can be different situations. So in proceeding will include appeal, revision, or review. So in all these cases, caveat can be filed. Like if a case has been adjudicated and a judgment has already been passed by the court, and it is completely against the defendant. Okay, so the court, let's assume a case of a recovery suit. A case of 50,000 was filed against the defendant, and the court has ordered to return 50,000 plus 10,000 as a compensation to the plaintiff. Okay, so in that particular case, the order is completely against the defendants. The defendant has a right. So the plaintiff here can anticipate that the defendant will go in appeal. So in this particular situation, the plaintiff can move a caveat in the anticipated court. Okay, so they can definitely assume that they are going to file in this particular court as per the jurisdiction, because we are not talking about any fact based question. So the court having jurisdiction, they will file the caveat in that particular court, and they will make an official request to the court that this party is going to file an appeal before this court. So whenever they file, the court shall serve a notice upon us, and without hearing the plaintiff side, they cannot pass any order on that particular application or on that particular appeal. Okay, so this is what caveat means. Now let's read the left portion of the section. Or proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lodge a caveat in respect thereof. Okay, so this is clear. Now the next subsection 2, where a caveat has been lodged under subsection 1, the person by whom the caveat has been lodged, hereinafter referred to as caveator, shall serve a notice of the caveat by registered post, acknowledgement due on the person by whom the application has been or is expected to be made under subsection 1. Okay, so whenever a caveat has been filed by a person, they will in advance serve a notice to the other party, to the defendant or to the opponent, whatever the case is. They will serve them with a notice. Serve them with a notice. Okay, so the next subsection is where a caveat has been lodged under subsection 1, any application is filed in any suit or proceeding, the court shall serve a notice of the application on the caveator. Okay, so here this section is binding the court that whenever a caveat has been filed, has been lodged. Okay, so here I will have to correct this term. Caveat is always been lodged, it cannot be filed. Okay, so we will use the term lodge here, just like FIR. Okay, so whenever a caveat has been lodged, in that case the court will duty bound to serve the caveator if the case has been made. Okay, so the next subsection is where a notice of the caveat has been served on the applicant, he shall forthwith furnish the caveator at the caveator's expense with a copy of the application made by him, and also the copies of the paper or document which has been or may be filed by him in support of the application. Okay, so this is binding the defendant side, which is expected to file an application, that he will serve an advance copy to the plaintiff of the application which are expected to be filed in the court. Okay, so and the last subsection is the limitation clause, basically, that a caveat will remain in force for only 90 days. Okay, so after the expiry of 90 days it can be renewed, but if it is not renewed within the time, then it will come to an end. So this was the provision of caveat petition. I hope this video has helped you a lot. Thank you.